Good afternoon and welcome to the Environmental Law Institute. You have joined us for the Summer School Series seminar, Hazardous Waste and Sites. My name is Chandler Randall and I am the Manager of Educational Programs here at ELI. We are so delighted to welcome everyone to ELI's annual Summer School Series, and I encourage you to join us here at ELI every Tuesday for Summer School. For more information, please see the events page of our website, eli.org. I will note that every Summer School Series seminar will be taking place by webinar only this summer to ensure the safety of our panelists, participants, and staff. Thank you so much for your understanding and for joining us today. At the end of today's panel, we will have time for a Q&A session. Please submit your questions through GoTo's question box, and please do not wait until the end. Send us your questions as soon as you think of them. I would also like to thank our outstanding panelists for joining us today to lend their leadership to Summer School. Well, I will introduce them briefly momentarily. The full speaker bios are posted on our website, www.eli.org, and I encourage you to check out their expertise in more detail there. As we begin, I would like to briefly introduce our panelists. Margrethe Kearney is the Senior Staff Attorney for the Environmental Law and Policy Center. Margrethe was previously a counsel at Latham & Watkins in the Environment, Land, and Resources Department, focusing on environmental enforcement, environmental litigation, and advising on environmental aspects of corporate and financial transactions. Charlotte Mooney is the Chief of the Cleanups Program branch in the Office of Resource Conservation and Recovery at the Environmental Protection Agency. Charlotte is an expert in all things RCRA and is a graduate of the University of Pennsylvania. Megan Roberts-Sedinsky is Senior Legal Counsel at Washington Gas. Megan previously served as Associate in Linos & Blaucher LLP and Venable LLP. Megan earned a Master's in Environmental Science from Towson University and earned her JD from the University of Maryland School of Law. With that, I would like to warmly turn things over to Charlotte to get us started. Thank you all so much.
Great, thanks, Chandler. It's so great to be here with these excellent panelists, and it's really exciting to be able to talk to you all. I have worked in the Resource Conservation and Recovery Act program pretty much all my career. It's kind of embarrassing. I'm not even sure I've done the math to tell you how many years it's been. It's been a long time. I worked in consulting before I joined the agency, and so I've seen sort of all sides of it. And I was really excited when ELI asked me to do this because I actually think it's one of the most interesting areas of environmental law to learn about, participate in, and I'm hopeful that all of you at some point will find yourselves helping out with the waste management program because it's a really important thing for our planet, actually. All right, so Chandler's gonna move slides for me because I'm afraid I'll do it wrong. So let's go on. This is what we're going to go through. I'm going to do a real quick overview of RCRA, and then we're going to dive into the hazardous waste part of RCRA. So we'll talk about what is a hazardous waste, who is regulated and how, the ever-famed definition of solid waste and recycling, which is a part of the program that I worked in for probably 20 years, and was a participant in lots of rulemaking and lots of litigation, although I think it's finally settled down. So it's an important part of the program and something you should be aware of. The Subtitle C Corrective Action Program is where I work now. I'm the branch chief leading the RCRA cleanup program, which is called Corrective Action. And then I'll briefly mention the enforcement authorities just because it's really important. People know they have to comply. So next page, Chandler. All right, overview. I thought that, you know, what should I mention at the very beginning, just in case you don't listen to the rest of this? There are some really important things to remember about the RCRA program. Number one, it's really complicated. I apologize for that, but it's really, really important. It's complicated for really good reasons, and I'll explain a little bit later when we get to the definition of solid waste. But it's really important that we manage all the wastes properly that we produce in all of our economic activity. And the way the regs are set up allows that to happen, that we can safely manage all that stuff that we generate as we're producing our amazing economy. And it's really very simple at one level. It's cradle to grave chain of custody management. And all of that system ensures that waste is managed properly. And the whole purpose of that is to prevent all of the other problems that we end up cleaning up later on. Second thing to mention, just in case you ever need to think about this again, states. The RCRA program is, for especially the hazardous waste side of the program, is implemented largely by authorized state programs. So if you want to call somebody about a site you're dealing with or a RCRA question you have, you probably should start with your state. Almost all of them are on the base program, we call it, the main part of the program. Almost a few less, but most of them are also authorized for the cleanup program. So think about starting with that state agency expert. Although I have to tell you, although it's a very complex statute, very complex regulations, there are incredibly expert people both at the federal level and at the state level. And so at the very end here, I'll give you my contact information, and please do feel free to connect. I'm happy to turn you over to the real experts in whatever question it is that you may have. So we've got amazing folks who can help you walk through any problem you might run into. Just to let you know, it's a famous statute. There are two quotes out of litigation that I think are worth knowing. The RCRA program has been called mind-numbing in one actual litigation, and also has been compared to Alice in Wonderland. So if that helps at all, if you're ever feeling confused when you're dealing with RCRA, it's okay. Just find the right people to talk to and it'll be all right. I guess with respect to the cleanup program, since we're talking about cleanup here a lot, I wanted to just say one thing right up front. The whole point of the RCRA program is that the owner operator of the facility is supposed to pay for the cleanup. So EPA doesn't do the cleanup, we don't pay for the cleanup, we just make sure it gets done. So that's very different than some of the other cleanup programs. So I wanted to make sure that's really important. The whole purpose is prevention and making sure that facilities clean up their mess before they leave, go out of business, sell property, disappear, to get that cleanup done so that it doesn't end up being cleaned up by the Superfund program or other taxpayer funded mechanisms. So the idea is the owner operator pays. All right, enough. RCRA overview, Chandler. The basic objectives of the statute and the program are to protect human health and the environment, to prevent pollution, and just it's that prevention theme constantly, to conserve valuable resources. Wow, that graphic didn't come through on the slide. Sorry about that. Public involvement in decisions. There are a number of places in the regulations where public hearings are required, comments, responses to comments, involvement at the community level. And then fairness, environmental justice, bringing in the community's concerns may be going on in their community. Chandler? Okay, so the statutory history, I know a lot of you are legal folks. I happen not to be, but that's okay. I've done a lot of assisting legal folks in our program. So I also care about the statutes, and this is the history of our statutes over time. And it really, you can see in the history of these amendments to the original statute, the changing concerns of our whole community as we learn more and more about how waste disposal can impact the land and the community negatively. So it started with just sort of trash management, and then it started thinking about resource recovery. What does that mean? And then in '76, the base RCRA program, which really built the whole hazardous waste management program that we're going to be talking about. And then the 1984 amendments, hazardous and solid waste amendments, colloquially known as HSWA, expanded scope and requirements a lot. Really added a whole lot of additional requirements and specified very, very, very particularly what EPA was to do in adding new requirements to the existing program. The Federal Facilities Compliance Act is something a little interesting, but basically says that federal facilities have to comply with RCRA too. Chandler? So here are the subtitles. I'm not going to read them to you. The one we're going to be talking about is subtitle C, and the regulations for subtitle C can be found in 40 CFR parts 260 through 278. Chandler? I promised these guys I wouldn't take up more than my time, so I'm going to keep moving. The basic sort of key parts of the program are identifying hazardous waste, which we'll talk about, tracking that waste from cradle to grave, and then making sure that treatment, storage, and disposal happen properly. And then there is the corrective action program, which is my current gig for the time, and is really an important sort of add-on to the hazardous waste regulatory program that we'll talk about. Chandler? The way the program is set up is that, in general, EPA develops regulations that are sort of the floor. States are then authorized. They come in for approval to EPA. The regions handle the authorization process. And once a state is authorized for a particular set of the regulations, they implement that in lieu of EPA. So it's actually not even a sort of a co-implementer structure. Once they're authorized for that part of the program, they are literally operating in lieu of EPA. Their regulations are in effect, and they're the regulations that you need to be paying attention to. States can be more stringent, so they can add additional requirements to the floor EPA regulations. And there is quite a bit of site-specific flexibility built into the RCRA program. There are lots of places where a permit applicant has to suggest different ways how they'd like to comply with a particular requirement. And then through the permit process, it gets negotiated and decided how that particular facility will comply with the requirements. I already told you how complex it is. And then there are some things to note. Every once in a while, there are some hazardous wastes or materials that are not regulated under RCRA, and the main example is PCBs, which has regulations that are somewhat similar to the RCRA regulations, but somewhat different, that are under the Toxic Substances Control Act. Chandler? Okay, so first we're going to talk about what is a hazardous waste. And this is fun, I promise. Chandler? So see, it's starting to get complex already. Is a material a solid waste is always the first question, and you'll see why in a minute. Is it excluded from the definition of solid or hazardous waste? You'll see why in a minute. Is it a listed or characteristic hazardous waste, or has it been delisted? With those basic questions, you can decide whether something is a hazardous waste or not under subtitle C, and hence subject to RCRA hazardous waste regulations. Chandler? So why on earth did that start off with solid waste? Well, the way the statute is written, it very clearly sets up this solid waste and then hazardous waste being a subset of solid waste structure. It also offers this incredibly interesting definition of solid wastes. A solid waste is any solid, liquid, or contained gaseous material that is discarded. Not what you would normally think of as solid waste. Physicists don't like it, but it's okay. A hazardous waste is a solid waste which, because of its properties, concentration of toxic materials, or some kind of characteristic, causes it to be likely to cause a problem for the environment or human health. Next slide, Chandler. And the way we implement that in the regulations is through two pieces of the hazardous waste ID program, which are listed wastes and characteristic wastes. Chandler? The listed wastes is a long list of very specific wastes. And if your waste fits into that listing, it's listed. If it very slightly doesn't fit that listing, it's not. So it's very important to pay attention to exactly how the listings are written. Some of them come from sort of generic industrial processes like wastewater treatment sludges from electroplating, from certain types of electroplating. So it doesn't matter where that production process is happening, whatever industry it's happening in, if it fits that definition of wastewater treatment sludges from a particular electroplating operation, it is a listed waste. Some are listed specifically within particular industries, and then there's a whole bunch of unused products that when discarded are listed as hazardous wastes. The criteria that we used for listing materials is there. So these are the criteria that we use when developing regulations to list a new waste. Those are the criteria that we have to demonstrate that material meets in order to add it to the regulations as a listed waste. Chandler? So characteristics is different. Instead of being a specific listing, it's these 4 characteristics: ignitability, corrosivity, reactivity, and toxicity. Those are basically things that there are tests that you apply to any waste at all. And if it meets one of those tests, then it meets that characteristic and is considered to be a characteristic hazardous waste. Chandler? Those are the 4 a little more explained a little bit further. I think you know ignitability, corrosivity, and reactivity seem kind of easy to understand. Toxicity, however, is different. It's a particular test called the characteristic leaching procedure. It's a particular lab test. You have to send your waste to a lab to have it run through that particular test to determine whether it meets the characteristic of toxicity. And basically what it is, it's supposed to model what it would be like for something to be in a landfill, in a non-hazardous waste landfill, over a certain period of time. So really basically it gets ground up, put in a container, and then shaken for a really long period of time. And then whatever leaches out into the leachate from that process is measured. And if it has toxic constituents above certain levels, it's considered to meet the characteristic of toxicity. Chandler? Okay, so that's it. Remember, it's got to be a solid waste in order to be a hazardous waste. Hazardous wastes generally listed or characteristic. So who's regulated and how? Chandler? It's basically a cradle to grave waste management system. Whatever happens to a waste from the point that it's generated until all the way, whatever processes it may go through, it may go to different places, it may go someplace for treatment, and then later someplace different for storage, and then later disposal. So whatever path that waste follows is tracked, and each step in that pathway has applicable regulations. And the basics for any step in that process are that the facilities must, or you don't usually, I'll tell you why in a minute, but facilities is sort of a particular term under RCRA, but the handlers is sort of a generic term, have to notify to EPA. They get an EPA ID number from us. They have to use the hazardous waste manifest to track, and then they have to comply with whatever the appropriate requirements for their handler status is. Chandler? So the cradle to grave tracking system is an elaborate system. I wish I had an old manifest, because the form is literally, it can be, I think what they used to print right off the bat was 8 copies, like carbon copies, literally. And it, it had all the hole punches at the top and the whole thing. But it's a particular form that requires the type and quantity of waste to be listed, where the material's going, who's supposed to be handling it, and each party has to keep a copy. First they sign it that they received it. They keep a copy. Then when it goes to the next person, that person signs and keeps a copy. So in theory, along that path, each person has a copy proving that they received and then sent off site that particular waste covered by that hazardous waste manifest. Chandler? That's what it looks like. Next slide. The reason that you don't really need to know what it looks like, however, is because we have a new system, yay! And this has really, really been a big change for the RCRA program. We now have, as of June 30th of 2018, an electronic manifest system. And you would think that it would be relatively straightforward to do such a thing, but the complexity of the paths that waste can travel and the requirements for signatures and documentation are actually incredibly complicated. And so to be able to make that whole system work, it's a very elaborate electronic system. There are currently 2 options, fully electronic. It can start at the generator and go all the way through to disposal using the electronic manifest. But we have a lot of generators who are small businesses and who are not quite ready yet to be part of the electronic system. So it is possible also that the initial transporter can initiate the electronic portion of that tracking. The electronic manifests do have a fee, which covers the system development and system use, which is actually kind of novel. It's not frequent in the federal government that we have user fees like this, but it's a good thing. And people always think, well, that's terrible, you have to charge, but the paper manifests actually cost quite a bit as well too. So especially as carbon paper becomes rarer and rarer. But there are lots of benefits to the program. Overall cost savings, increased accuracy and timeliness, and better notification if something goes wrong in that system. Also, folks who are using the electronic system can use that data for other reporting. Chandler? So the e-manifest is actually a pretty exciting improvement in the program. So the person who starts the whole waste management system is the generator. And that's the definition there. It's a person by site whose act or process produces hazardous waste or first causes a hazardous waste to become subject to regulation, which is a little tricky. There are lots of exclusions as to when a waste may not be regulated. And so that's why we need that sort of when first causes it to become subject to regulation. There are 3 types of generators. As you can see, I love this. VSQGs, SQGs, and LQGs, very small quantity generators, and large quantity generators. And you can see the quantities there. It's measured per month. And next slide, Chandler. Each generator category has sort of gradated requirements. The smaller folks have less requirements up to the large quantity generators who have the most requirements. But the requirements basically follow this pattern. ID numbers, accumulation times and quantity limits for keeping waste on site, contingency plans, employee training, units like tanks or containers where they may be storing their waste have sort of technical requirements, compliance with the land disposal standards that I'll talk about in a little bit, and then tracking using the manifest. Chandler? Transporters, pretty straightforward, have an EPID number and make that manifest tracking system work. The DOT regulations actually have all the safety and emergency response type of things built in. So that largely comes through the DOT regulations. Chandler? So treatment, storage, and disposal facilities. These are the folks that store, treat, or dispose, obviously, hence the name, of hazardous waste. And they are the ones who really are the key sort of keepers of the insurance that all waste is managed properly through this program. And they require a permit for their activities, and the permit is very elaborate and very thorough, runs through all the activities that a permittee might do with hazardous waste and has specific requirements for those. That gives you kind of a summary of what's required. Chandler? I just wanted to mention a couple of key things. Closure is really important. If you have a facility managing hazardous waste, they can have a lot of waste and they can have a lot of nasty stuff. So making sure that they don't just disappear at the end of their active life and that things are managed properly is what makes this a prevention statute and keeps us from creating Superfund sites. So the clean closure means that all waste that has been managed there is removed and the site decontaminated. And then waste in place is basically a landfill where the material has been treated and disposed of, and that landfill has to be constructed, capped, groundwater monitoring installed and maintained, all kinds of requirements over time for post-closure care to ensure that that material is not damaging to the local community. Chandler? Financial assurance also, basically the permittee is required to demonstrate that they maintain over time adequate financial resources to cover things that might go wrong, and also to project ahead what closure requirements they will need to meet and that they will have financial wherewithal to cover those closure and post-closure requirements. Chandler? Okay. I had to throw the definition of solid waste and recycling in because I guess everybody thinks it's exciting, and largely it's exciting because it's confusing. However, Chandler, next slide, it's really important. And I think that the other day I was thinking about this, it's like, why is the definition of solid waste so confusing? So remember, a material has to be a solid waste before it can be a hazardous waste. So it can't get into the regulatory program unless it's a solid waste. Well, why isn't it really easy to know whether something is a solid waste? And this gives you the structure for how we decide. You have to know two things. What is it and what's being done with it? You have to know both of those things. So why is it so complicated? And I was thinking about it. You know, for a long time, you probably were throwing all your plastic containers into your recycling bin. More recently, you might have discovered that it's possible that some of that plastic was not actually getting recycled. So where was it going? What was happening to it? You have no idea. Maybe you saw a recent expose explaining, but you don't know. So for all that time, you thought that material was being recycled, and it was not. So that, I think, demonstrates the complexity of how much it takes to know about what actually happens with a material in order to know whether it really is being recycled or is it being managed and disposed of as a waste. So hopefully that example helps. Next slide, Chandler. This is a table that, believe it or not, is actually in the regulations. And what it basically, you don't need to look at it other than across the top is the types of activity that are happening with the material, and across this down the side is what type of material it is. So these are all categories of materials that could be hazardous waste and types of recycling processes. You have to know both of them. And if there's a star in the box, it's a solid waste. If it's hazardous, it's then regulated when recycled. If there's a line in the box, i.e. not a star, then that material used following that activity is not a solid waste and hence cannot be a hazardous waste and is not regulated. And the whole structure of this thing is really basically designed to try to deal with the complexities of things like that example that I just gave you. Chandler. I just wanted to mention this because it's more recent. There are 3 new exclusions, of which there are many in the regulations. Many, and I mean really many. I think there's 28 or so exclusions from the definition of solid waste. These are 3 of them, quite recent, which are, again, really, they're quite detailed, but they're getting at that idea of you have to know what's happening in order to know whether something is really being recycled. The generator controlled exclusion, I think the names kind of give you a sense of why they might be recycling rather than waste management. The transfer-based exclusion, each of these have elaborate conditions, and then the remanufacturing exclusion. Chandler. So this is my favorite slide in the whole presentation. So there is also a question of whether recycling is legitimate. So the container, plastic container not being recycled gives you an idea of how complex it is to determine whether something is being recycled or not. This example, I think, really explains exactly why it's hard to know whether something, even if you think it's being recycled, whether it's legitimately being recycled. And this example is real, believe it or not. The pictures are not from a real case, but it actually was a real situation. In a foundry, leaded sands are used to make the molds, which you can see there on the left-hand side. After the casting happens, the molds get broken down into sand, and they can be reused for a certain period of time with additives and sort of good care to make new molds. However, at some point, it cannot be reused any longer and has to be done something else with. Using it in playground sand is not a good recycling option. It's not legitimate recycling. And I'm telling you, it's a real case, believe it or not. So this question of legitimate recycling is difficult. Chandler? These are 4 factors that are used to determine whether something is legitimately recycled. Basically, you have the material has to meet factors 1 through 3, and then factor 4 has to be considered. There are lots of sort of nuances in that factor 4. But I thought it was worth you just seeing that it's a difficult, again, it's a complex set of regulations, but it's aimed at really trying to accurately determine whether something really is waste and needs to be regulated as such or not. It's more like a product, it's more like something that's being used in the economy and should not be regulated. Next slide, Chandler. Okay, corrective action. So this is my baby. Currently, Chandler, next slide. So I just wanted to tell you a little, and I apologize, I can't believe there's a typo on this slide. Ugh, nevertheless, this is what we do. The left side is cleaning up contaminated sites, and the right side is what we hope they end up like after getting cleaned up and redeveloped. Next slide. There are currently about 4,000 facilities in the RCRA Corrective Action Program. And I wanted to be really clear that treatment, storage, and disposal facilities are the only handlers in the RCRA program that are subject to corrective action. So generators are not, transporters are not. They have to manage their stuff correctly and not spill. But treatment, storage, disposal facilities where all that waste ends up are subject to this requirement in the RCRA program. Chandler, next slide. Which comes out of the statute, and HSWA, the 1984 amendments added these 3 provisions, which basically require that any treatment, storage, and disposal facility must clean up any releases, past or present, facility-wide. So it's a pretty extreme requirement, and the idea is to make sure that those facilities clean up any past activity that may have been a problem and anything that happens during their operation in order to ensure that facility does not become a Superfund site. And the regulations are cited there. However, I will just to let you know, the program has a very basic set of regulations, but it's largely implemented through guidance, and the procedures are on the next slide, Chandler, which shows you roughly the basic process that we go through. That's weird. The process isn't there. Oh, here we go. There are basic steps that we go through. They're basically check the entire facility to see what problems there might be, assessing those problems, identifying how those problems can be cleaned up, and then performing that remedy. Next slide, Chandler. And I just wanted to show you, these are the measures that we use to track our progress as those 4,000 facilities track through the cleanup process. This is how we know how we're doing. And there are 4 on this slide and then 1 on the next slide. These are the basic 4 we've been using for many years. The first 2 are environmentally oriented. Human exposures are under control at the site, which is really important. And that contaminated groundwater is under control. So it's not migrating from the facility. It's at least being maintained and hopefully being either pulled back in and treated or treated in some way so that it's no longer hazardous. Remedy construction means you've actually built the remedy, which might be putting in a pump and treat system, pumping groundwater and treating it, or actually dig and haul, we call it, which is basically digging up all the contaminated soil and taking it away. Performance standards attained means the cleanup objectives have been met, and so the cleanup has been completed. And the next slide, I just wanted to show you this one because it's been focused on a lot more in this administration. Ready for anticipated use, it's called, which basically means that whatever has happened at the site has cleaned up enough that site, although not completed, the cleanup isn't completed yet, what's been done is sufficient to allow some kind of use of that facility. And I think the classic example is if you have contaminated groundwater, soil has been, let's say, dig and haul. You dug up all the soil, took it away, replaced it with clean soil, but the groundwater is still contaminated. Pump and treat may be going on to clean up that groundwater. But if you put a cap over that area, it's safe, for example, to build a parking lot where you'll have a asphalt cap and no one can be exposed to that groundwater. Next slide, Chandler. So this is just illustrates those 4 measures, the first 4, how much progress the program has made over time. It's a slow process cleaning up sites, but we're getting there. Next slide. All right, enforcement. Yes, people have to comply. Next slide, Chandler. So there are enforcement provisions built into the statute, and we have an entire enforcement office whose job it is to make sure that people do comply with the applicable regulations and that any issues that need to be addressed get addressed. So I think that's it. I hope that's given you a sense of, I know you'll assuming you're going to be working in the environmental field, you'll be hearing complaints about the RCRA program, but I think it's really important to understand that there are reasons as to why it is very complicated, and that there are folks out there to help anytime you need it. So there's my contact information. Please feel free to shoot me an email. Email's best, but just let me know that you were here at this session, and I'll be happy to help you find the right people to talk to. Thank you.
Well, thank you so much. We'll hand things over to Megan now. Thank you.
Great. Thank you so much, Charlotte. That was fantastic. Good afternoon, everybody. I am excited to be here with all of you. I'm disappointed we can't be together in person and get to chat a little bit afterwards, because I think that's also an important part about the summer school series in particular, is the opportunity for you to meet people in the field and understand, you know, what their path has been and how they ended up, you know, here talking to you today. So I just wanted to, you know, offer to people who are interested in, you know, my particular path, which was environmental consultant to, after law school, I did a clerkship, then I was in private practice, and now I'm in-house with Washington Gas. And, you know, I'm happy if you want to find me on LinkedIn, reach out. Happy to, you know, give you some information about my path if it's something that interests you. So I'm here to talk to you about, let me make sure I can get the slide going. And that's not work. There we go. So I'm here to talk to you about Superfund basics and state program basics. And, you know, most of you probably heard of Superfund. It's a really important and complex federal statute, but I also, that sort of governs cleanup of big, really nasty sites. But I also thought it was important for you to be exposed to state Superfund and state voluntary cleanup programs, because they're really the sort of spectrum of ways that sites can be cleaned up. You know, Superfund tends to be pretty cumbersome and time consuming. So a lot of times, you know, property owners will opt to go through a voluntary program and end up with, you know, hopefully similar outcomes that are protective of health and human health and the environment, and, you know, accomplish the goal of getting properties back into beneficial use for the economy. So the first, I just want to set my timer real quick. The history of the Superfund statute, it was enacted back in 1980, and so we learned from Charlotte that, you know, the solid waste laws and the RCRA laws were in the 60s and 70s, and part of the Superfund, you know, sort of mandate was, you know, in part because of issues that we had, like Love Canal and the Valley of the Drums that you've probably heard of, that the existing laws weren't really adequate to deal with the big mess that had been left from decades of industrial development and use and contamination. So Superfund sort of comes with two parts. One is the fund part, which was a tax on certain companies, chemical and petroleum companies, and that tax created a fund that would help pay for cleanup. But also the other aspect of Superfund were sort of these very strong, you know, and Margrethe is going to talk about the liability issues a little bit more, but also the response authorities and the strict liability and the, you know, polluter pays, you know, strong mandates of the law. So it's in two parts that the CERCLA Superfund law went to go after these long-term contaminated sites. So similar to RCRA, the goals, you know, were to protect the human health and the environment, you know, focus on involving the communities that were impacted. You know, there's an environmental justice aspect of this, that, you know, public participation, it shouldn't be that certain communities are more negatively impacted by contamination. And, you know, the polluter pays principle, that's really important aspect of CERCLA, and that trickles down to the state programs as well. And also, as I mentioned, returning land to productive use. Over time, you know, since 1980, there have been a lot of amendments to RCRA, or excuse me, to CERCLA, but I just wanted to highlight two for you. The ones that you hear most often are the SARA amendments, which were 1986, and the SARA amendments really sort of moved, you know, moved Superfund into addressing, permanent remedies and innovative treatment technologies. The government's starting to learn how this is going to go. The CERCLA amendments also raised the cap on the fund. The initial fund after between 1980 and 1985 raised $1.6 billion, but that was capped, and CERCLA raised the cap to 8.5 billion. So it really, provided a lot more, resources to the government, where you had polluters who were, nowhere to be found, bankrupt, didn't have the resources that they needed to clean up the sites. It really gave the government more resources to work on those sites. The second amendment that I put down here was the Brownfields amendments in 2002, and I highlight that because, again, now this has been 22 years after CERCLA was enacted. Everyone sort of realizes this is a long-term, sort of cumbersome process. We want to, engage the states and, create voluntary programs that can perhaps be more efficient to get properties through the cleanup program. And I'm going to talk about that a little bit more. But, CERCLA gets, updated, minor tweaks from time to time. Even as recently as 2018, which was the Build Act, and that actually modified certain provisions in CERCLA. And I'm going to talk a little bit about this, the bona fide prospective purchaser defense, and it expanded that to lessees. So it's always sort of a work in progress. Okay, so CERCLA applies to uncontrolled releases, or importantly, threatened releases of hazardous substance. It gives the government the authority to go in and take action proactively, not just, these aren't all just very old legacy sites. And the sites that are eligible for CERCLA action are where there's an imminent and substantial risk to public health and welfare, which you see in sort of a lot of these federal environmental statutes. Importantly, petroleum, natural gas, crude oil are excluded from CERCLA. You'll hear the term, the petroleum exclusion. So these sites, sometimes, if you had a pure petroleum site, that would be excluded, but a lot of time petroleum is also commingled with other types of contamination. So you have ways to address that. If you have a permitted release, that's not covered. Certain recycling transactions, and then there's also just sort of another list of other things like asbestos that aren't covered. And you could, certainly, I'm trying to drop a few notes in here in this big statute that if you go back and you wanted to look at the slides, you'd be able to find your way to some of these provisions in the statute. So there's CERCLA provided the response authorities. I'm going to talk a little bit about that next, and then the enforcement authorities. So there's two types of response authorities under CERCLA. There's the government's removal response authority, which you can sort of think about something that would happen in a short period of time. Is there an emergency? Is there some sort of leaking drum, that the government needs to be able to go in there and, clean it up, contain it? There's some sort of threat to human health or the environment that's very imminent. But so I'm using this whole idea of imminency, but there's, under the removal authority, there's time critical and non-time critical pathways, which I'm not going to go into too much. I just want you to be aware that depending on the level of the threat to human health or the environment, you can sort of be into an absolute emergency phase, or a non-time critical removal can actually take 1 to 2 to 3 years. So what you start to see with CERCLA is these processes can take many, many years, but there's also provisions that can act very quickly. And then so sort of removal is what happens in the very beginning, like we've got to scoop up this stuff before it gets into the waterway. But then you go on to the next stage, which is the remedial response. So that's for your traditional Superfund site that you think about. And this is the long-term assessment, the identification of the site, the assessment, and then taking it through the cleanup process. And that's what you have with the remedial response authority. So the cleanup process, Superfund is very process oriented. There's lots of steps. That's why I sort of say it can become very cumbersome. But first thing that we're going to talk about is the site's identified. Like, how does it come to the attention of the EPA through the state? Is it a citizen complaint? Is it some sort of massive, casualty or fish kill or something. There's various ways that the site can be identified for the Superfund program. Then there's a preliminary assessment with soil and groundwater testing, sort of really just trying to gather basic information about what types of contaminants are there, what is the likelihood that they are, migrating off site. And then that goes into the site evaluation. So the EPA has the hazard ranking system where there's certain questions that are asked based on the contamination that's found, the location of the site, the potential receptors, and all of those are sort of put into a ranking system where where the government is able to evaluate the risk of that site and decide where it needs to go in the program. Does that go to the national priorities list, the NPL? You'll see that acronym frequently. Those sites that are the most serious sites that need cleanup will go on the NPL, and they start on their own pathway. But there's other ways that the government can deal with the site. If it's not that serious, it can be put off into other different types of remediation programs. And one thing, if you wanted to go to EPA's website, you can look at what sites are on the NPL in your area. They have really good mapping tools and information about all of the sites and what stage of the process they're in, and you can get the documents. And I think EPA does a pretty good job of providing information to communities, because as I mentioned earlier, part of this process is engaging the communities. It's making sure that people are aware and educated and involved in the whole process. So after you have reached the status of NPL site, whether you think that's good or bad, then you go through the next process, which is the remedial investigation and feasibility study. And that's sort of one bullet in my slide here today, but this is just depending on the complexity of your site. This is a very, very critical, costly, important analytical tool. And I'll talk about this, but this could be 3 to 5 to 10 years, depends on the complexity of your site. Then you have a proposed plan, record of decision. Then you get into remediation, operation and maintenance, and then hopefully delisting at the end. So the remedial investigation, or RIFS process, as we call it, the remedial investigation is really gathering all the data. It depends on what type of site you have, what type of media. So let's think about a landfill site. And let's say there are streams nearby or a river nearby. The remedial investigation is going to involve, doing soil borings, collecting data on the geology, on the nature and extent of the contamination, what types of pollutants, what levels are the pollutants, how are the pollutants moving throughout the site, and probably most importantly, are they moving off the site? Are they reaching sensitive receptors? Where they are reaching sensitive receptors, are there risks? And I'll go into this a little bit more, but risk is clearly defined, so there's a process that EPA has set up for, determining the levels of certain constituents and the exposure by the receptors to determine whether there's a risk. It isn't sort of an arbitrary determination. And then sometimes during the remedial investigation, or sometimes after that, either the PRP, the potentially responsible party, or the government, depending on who's doing the cleanup, will do a treatability study to start doing some initial testing. Because a lot of these sites, the treatment technologies are evolving over time. There's excellent consultants out in the field who are learning a lot through these sites. Different types of remedial technologies work better on different pollutants. So there's a provision that allows everyone to get together and sort of test and see if it's going to work out before you move to the feasibility study, which is where you basically develop remedial alternatives and look at the various types of pros and cons of each alternative. So if you are an NPL site and you are moving through the feasibility study, the CERCLA statute actually provides certain criteria for selecting your remedy. And there are these two important threshold criteria, which are overall protection of the human health and environment and compliance with ARARs. And I have a slide on both of those. Those are the most important. But then it's also really important for everyone to understand that that as long as you meet those two, then you have other criteria that you can look at, that the agency can balance, that stakeholders can comment on, that the PRP can comment on, and these are sort of where you really get, I think, get productive discussions about, treatment technologies. Is that going to be the most effective? What is the, long-term sustainability of that? How effective is your remedy in terms of keeping the pollutant where it is? Let's say you come up with a barrier treatment. Well, is that going to work for 20 years or 100 years? Should you really be scooping it all out? And you will balance that against things such as cost. So it might cost you $1 billion to scoop it all out, and a barrier system costs $10 million. And what are the pros and cons of both of those, So those are things that, that really is where the ultimate remedy, comes into play when you sort of hash out all of these things. And then also the EPA considers, agents, and it's not just EPA, I shouldn't be saying that under Superfund, there can be other, Superfund delegated through the states or through the other jurisdictions. There can be various lead agencies who are sort of making this call. So they will also look at what do the state stakeholders think and what does the community think? And because there's so much of a public back and forth, there's a really good opportunity to get buy-in from all of the stakeholders. So protection of the human health and the environment, and that through the process, through the feasibility study and the proposed plan. So you do a feasibility study, you say I have, 6 different alternatives, and as part of this process, the PRP develops remedial action objectives, which are approved by the agencies. And these are sort of, they can be numeric guidance document or, guiding principles, which might be if you're, let's say, looking at a site that's contaminated by PCBs and during the remedial investigation, your risk assessment showed that there was this amount of risk. So you can create, and your analysis will show that a certain level of PCBs would lower the risk to an acceptable level, and that would be your remedial action objective. And all of the proposed remedies must meet those remedial action objectives. So there's also, those become very important for the ultimate determination of the site. And so for determining what's an acceptable risk, there are 2 different ways that can be done for carcinogens. There are these amazing risk assessors who can look at the amount of the contamination and the exposure and figure out what the lifetime cancer risks are. And then for all other toxics, there's a different, it's called the hazard index, and it looks at overall adverse effects. So sort of one of the important parts is how is this area going to be used? How should the stakeholders be able to use this? If you have a site that's adjacent to a waterway, are people going to be kayaking? Are they going to be swimming? Are they going to be wading? All of those current and future expected land uses are important and relevant to meeting your remedial action objectives. So this is sort of an interesting part about Superfund, because you have a lot of these very highly industrial areas, and you don't necessarily think about people being able to wade, in Love Canal or, the Long Island Sound or parts of New York or even DC. But these are sort of the expectations that we'd be able to return these areas to use that is, all of the citizens should be allowed to have. And as part of this, as I mentioned, the risk assessment, you have human health risk assessment, but you also have ecological risk assessment. So in a river scenario, you'd be looking at the impact to fish. You'd be looking at the impact to larval fish and the macroinvertebrate that eats that, and then the eagle that eats that. So it's a very comprehensive program that looks at sort of all parts of the life cycle of contamination, which is it's very interesting, but it also is very time consuming and resource intensive. The other sort of threshold criteria, if I can get this to go to the next. are what we call ARARs, applicable or relevant and appropriate requirements. These are put together during the remedial investigation and feasibility study phase. And these, I'm sure we'll hear a little bit about litigating ARARs, but these are, sort of, and if you can imagine, you, the agency, the PRP, look out into the landscape of statutes, regulations, guidance documents, and figure out what might apply to your remedy. And if it applies to your remedy, let's say it's the Clean Water Act and the NPDES program under the Clean Water Act, you need to make sure that your proposed remedy will meet all of the requirements of whatever law or regulation or policy that you have designated as an ARAR. So this could be something that is, very highly litigated. If you choose, you're acknowledging and accepting that these particular laws would apply to your remedy. You need to be able to show that you meet them, because if you can't, then that makes the proposed remedy subject to litigation. If there's something that's going to be completely impossible, like protection of water for drinking, and you are in a very highly industrial area and there are no human drinking water wells within 100 miles, there are provisions where the agency can waive the ARARs. But that's a pretty complicated process, but it's very important to make sure that you document all of these if you want to have a defensible final remedy. And the ARARs also have to be supported by the state, because it's state requirements, it's not just federal requirements. So after you've gotten through all this process, you've figured out, you've done your balancing, you've picked out your remedy, you put forth a proposed plan, and the proposed plan says, here's what we're doing. And it goes out to public comment. There's generally public meetings, it's published, the agency accepts comments, the agency has to reconcile the comments, and once it's done that, it issues a record of decision. Once the record of decision is final, it's not been appealed, whatever the remedy is and the ROD goes forward, and that is where you develop your remedial action and implementation of the process. After that, you have your construction complete document, but you're really not done, because you need to monitor, you need to make sure that your remedy is adequate, that you are operating it appropriately, and then you can return to productive use, but certainly not without additional requirements, and I'll talk about that. So I'm just going to very briefly touch on this, because we're going to hear a little bit more about this in the litigation sense. But, as I mentioned in the very beginning, CERCLA is, strict liability, strict joint and several liability, and CERCLA 107A provides 4 classes of potentially responsible parties. And that is the current owner or operator of a contaminated site, owner operator at the time that the disposal occurred, generators, and transporters. So we'll hear a little bit more about that. But as I mentioned, there are provisions that the PRPs can take the lead on the CERCLA process, or EPA can take the lead and the PRPs can reimburse EPA. Generally, that's not how it goes, because the PRP wants to have a say in what's done and how much it costs. But if the PRP does it, every single step of the way, every document is reviewed, every work plan is reviewed, and EPA or the other agency has significant oversight over the process. So as I mentioned, there's a strict liability, joint and several liability, and there are provisions for contribution. So if I am strictly liable as the owner of the property now, I might have what's called a contribution claim against the owner of the property if I bought it from somebody else when the disposal occurred. So there are some equitable allocations of responsibility, but of course you have to litigate that, and that's many cases about contribution. And then the factors that are considered, they're really equitable, factors. How much did you contribute? How bad was it when when the release occurred? How much were you involved? Were you just the holder of the land and somebody else sort of spilled it? And have you, cooperated with the government? So obviously those are all very fact specific, so you can imagine that would be ripe for litigation. So, you know, CERCLA sounds scary. It's joint and several, it's strict liability. No one really likes that. and so there had to be some relief valves in the statute. And there are statutory liability protections. The innocent landowner defense is for people who have purchased land without knowledge of contamination. And that applies to governments who have involuntarily taken or had to take land through eminent domain, and also people who inherit properties. The contiguous landowner defense, that came through the 2002 amendments, and that protects people who own adjacent properties where contamination has migrated onto the property. But there's, you know, certain requirements to qualify for that defense. You can't buy land that's next to a landfill and know that it's contaminated and then say, oh, I'm a contiguous landowner, don't come after me. So you have to, you know, you have to buy without knowledge, and there's certain requirements that you have to meet that also apply to this, what we call the BFPP purchaser, prospective purchaser defense. So you can't, one of the important rules is that you can't have, there's no affiliation between you and the, you know, the prior owner or the sort of the responsible party. You can't have a corporate reorganization and get out of the, you know, get out of the responsibility. And you have to cooperate with the government. You can't dispose of additional chemicals after and say, sorry, it was that guy's fault. So there's a lot of requirements. The BFPP defense comes up very frequently now in real estate transactions. And this one, there's also lots of good litigation, but the idea, again, being that we want to get land back into productive use. And so we want to encourage people to buy properties, to conduct what we call all appropriate inquiries, which is set out in the regulations, and do due diligence on a piece of property, really understand what's there, go forward and buy it, do the cleanup. But you have to make sure you check all the boxes in the statute and the regulations in order to qualify for this defense and not have an agency take action against you. And then I also wanted to point out the 107B3 defenses. These are, you know, these are specified in the law, but you know, they're pretty difficult to qualify for. So people bring them up, but they're subject to a lot of dispute. So state Superfund programs, all of what I sort of described, the overarching themes are what you find in these sort of mini Superfunds. But one of the important parts is almost all of these state programs exclude sites that are on the NPL or in the RCRA Corrective Action Program. So, you know, they're intended to sort of capture the next level of sites. The states also have emergency removal and response actions, and you know, they're subject to the same sort of long-term remediation. Some states have cleanup funds or financing mechanisms, tax credits, what have you. Voluntary cleanup programs, this is where, you know, I was coming from with the brownfields amendments. You know, the idea being, how can states motivate owners or potential purchasers of contaminated property to voluntarily remediate contaminated properties? And we can do this by protecting them from liability, from, you know, enforcement actions by the state, and also by providing tax credits and financial incentives. And different states have different programs. Some have statutory tax credits, some have financial incentives in the code, but they've never really been funded. So it really does depend on your state and, you know, sort of what the level of interest in your state is in terms of providing incentives. Voluntary cleanup programs are available to people who have owned, you know, they are a responsible party. They might have been the original polluter, but they're all, you know, but the idea is, let's get everybody together, let's, you know, get on the same page and get these sites cleaned up. So depending on whether you're a responsible party or an innocent purchaser, you'd get different types of sign off and certainty. So it's very important before you go into one of the programs to understand what you might get out of it. And similar to the state Superfund program, NPLs are not typically allowed in voluntary cleanup programs. Neither are sites that are under enforcement actions. And this is also sort of a motivation for people to voluntarily clean up sites so that they don't end up in an enforcement situation. If you jump and get into the voluntary cleanup program, you have protection against that. And I added this, how dirty does the site need to be? Because we have sort of the spectrum. We have the CERCLA, the NPL sites, the sort of the worst, and then you have sites all the way down. And a lot of these voluntary cleanup program statutes sort of talk about sites that are contaminated, but also have sort of the potential to be contaminated, or you know, sort of the stigma of contamination, just sort of being in an industrial area. That's also relevant. If you go through a voluntary cleanup program, because you're doing this yourself rather than being in an enforcement posture, there's a lot more work that you do in the beginning, which is develop the background information. And another, although, you know, as the remedial action objectives and certain aspects of the Superfund site do consider what the ultimate use will be, the voluntary cleanup program criteria and success really are just driven by what's the ultimate use of the property going to be. And just like Superfund, there's public participation, there's different processes you can go through, corrective action, response action, depending on your jurisdiction. And then, you know, I just wanted to sort of highlight different aspects of the voluntary cleanup program. There's also site-specific risk assessments, just like with Superfund, but also institutional engineering controls are very highly, you know, very important to the program, because long-term this needs to be beneficial and safe. And once you're done with the voluntary cleanup program, you walk away with a certificate that protects your rights moving forward. And that's also limited to what you included in the application. So it's a little bit different than Superfund. And that's it. Thanks.
Thank you so much, Megan. And now we will hear from Margrethe. Thank you.
Great, thanks. And I just want to make sure that you're hearing me.
Yes, we can hear you.
Yes, okay, good. And if there's a small child that runs in every now and then, my apologies. I know that we are all in strange circumstances working from home, and I wish that we could all be together and even go out for a cocktail after this in DC. Wouldn't that be wonderful? But I'm, by way of a little bit of background, was in private practice for almost 10 years in Chicago doing environmental litigation. And I was represented mostly parties who were fighting with each other about who was going to pay for cleanup at some pretty big Superfund sites. So I was involved in a couple of pretty large CERCLA litigations, and since then have jumped to the other side of the V and now work for a nonprofit environmental advocacy group doing clean energy and protection of natural spaces. There is not nearly as much of the type of litigation I'm going to discuss with you now in that nonprofit sector, because this type of litigation really is something that happens between the PRPs by and large and the governments. And so while there's a lot of stakeholder input that is provided throughout the process, while people who live in areas that are impacted by contaminated sites certainly have concerns and issues and are involved in a lot of the processes that Charlotte and Megan just talked about, it is not as common to see groups engaged, nonprofit groups or community groups engaged in actual litigation, because the litigation is pretty intense and really is about trying to allocate the responsibility of the cleanup and the cleanup costs amongst the folks who are liable. And I did take some great notes that reminded me of things that I forgot to include in my slides. And so I'm going to reference those and move back to some of the things that Megan and Charlotte said as they were talking about the administration of these programs. So the first question, let's see. Here we go. I can get it right, I promise. So hazardous waste and sites. So, you know, the kind of my subtitle for this was when we can't agree, we litigate. This litigation in the hazardous waste context happens after often years and years of work with folks like Charlotte and in programs like the ones that Megan described. And so there's always a very long background that you need to be aware of whenever you get involved with an environmental litigation over a hazardous waste site. There's been communication with the regulators. There have probably been settlement discussions. There might have been cleanups. There's a lot of history there. And the first thing that you need to do as a litigator is get your arms around that history, talk to the people who were involved in the site, talk to the people who know it best. Environmental litigators aren't necessarily environmental attorneys, right? So a lot of folks are litigators, and they litigate environmental issues, and then they litigate contract issues. So like any other type of litigation, you really have to dig in on the issue in the area you're involved in and figure out what the history is and what's going on. I will say that when you get into the very complicated and complex sites and cases, that litigation does tend to be handled by firms and by attorneys who do exclusively do environmental litigation, because there's just so much to know about the statutes. There's so much to know about the way in which these regulations apply that it can be hard to kind of jump in without having had experience in the environmental field. And when I'm talking about litigation under these statutes, I'm not talking about litigation of these statutes, right? So whenever there is a federal law that is passed that regulates the environment, at some point it's challenged by someone as going too far, being beyond the authority, not, you know, violating the Constitution. There are all those challenges. A lot of those challenges have sort of come and gone with respect to CERCLA and RCRA, because they've been around for a while. So I'm talking about litigating under these statutes, not litigating the statutes. All right, so the first thing to learn, and this is my favorite quote from, keep getting too far, from my environmental law professor when I was in law school, was CERCLA does not care about you, right? The statute does not care who you are and whether you were trying to be good and you didn't mean to do anything. You're liable, right? You have touched the site, you're near the site, you're around the site, you smelled the site, you're liable. And liability is strict, it's joint and several, it's retroactive. So it does not matter if in the late 1800s, whatever company that, you know, ended up being purchased by Joe and Fred and John and Pete didn't know that CERCLA was going to be passed and didn't know that they were going to have to clean up these sites. It does not matter, right? CERCLA does not care that you did not know CERCLA was going to be passed. It is retroactive. And there are a number of things that Megan talked about, and I won't go over in too much detail, but there are kind of these 4 basic things that you need to demonstrate in any sort of a CERCLA case, right? So there are 4 things that bring you under that statute, that create liability under CERCLA, and that if you are a plaintiff and you are a potentially responsible party and you're trying to bring other responsible parties into a case so that you can figure out how to pay for a site cleanup, so that you can allocate site cleanup amongst those groups, these are things that you will have to prove. If you are being brought into a case and it is being alleged that you are a potentially responsible party, these are the things that you have to say, nope, I don't meet one of those elements. You can't say that I am liable under CERCLA. Government parties also, I know that there are a number of folks who work for state or federal agencies that are probably watching this and on this. These are also things that you would need to show in order to demonstrate liability, to get parties to engage in the kinds of cleanup discussions and regulatory discussions that we just heard about. So all that stuff that happens before we litigate it, you've probably been talking about this for years and years and years and years, right? Because you don't go to a company and say, we want you to clean up this site but we don't really have any basis for believing that you're going to fall under the jurisdiction of the statute. All this stuff has been talked about for years and years and years, and there's probably a wealth of evidence that's kind of sitting around in boxes or online that you will want to access and to really understand before you jump in litigation. So let's say I'm, you know, an owner of a site, and it turns out that it's just absolutely filled with PCBs, and I need to clean it up, and it's going to cost me billions of dollars. And I say, well, wait a second, I'm not the only person who's ever operated at this site. I want to make sure that other people have to pay for their fair share of what happened here. But CERCLA doesn't care about me. CERCLA doesn't care that there are other people who should pay for this cleanup. They say, you know what, you got to pay for it all, and it's your job to go out and find all those other folks who you claim have some responsibility. So I would go out and try to find all of those folks and put them into the CERCLA box and make sure that I can prove liability in my lawsuit. So I'll need to show one of those areas that they're a current or former owner or operator that Megan talked about a little bit, and that they're generators or arrangers. So one thing I noticed, and I'll talk about this on another slide, is that Megan framed it in terms of generators. I tend to think about arrangers as being kind of the hotter and more complicated legal issue in this context, is who is an arranger under CERCLA. And then transporters is another group of folks who can be liable. So basically, if you own the site, if you operated the site, if you operated on the site, if you sent stuff to the site, if you arranged for other people to send stuff to the site, if other people had you transport stuff to the site, if you got close to the site, right, there's probably going to be some way of trying to get you in to that first element. There has to be a release or threatened release of a hazardous substance. Those tend to be, I think, fairly straightforward things to demonstrate in litigation, because there usually is a pretty long history and a pretty long record of agencies having looked at the sites, looked at whether there have been releases, whether the substances are hazardous. So those, I think, tend to be less commonly litigated issues. And then also from a facility. That is an area that I think you tend to kind of gloss over a little bit. Like from a facility can mean almost anything. The way facility is defined is super, super, super broad. When you're going in and you're drafting your complaint, or you're responding to a complaint that's been brought against you, take a look at how the facility is defined. Think about really what we want to think about as the facility. Is it the paper plant? Is it the wastewater treatment plant at the paper plant? Is it the pipe that leads from the wastewater treatment plant to the river? Might not make a difference at the end of the day, but definitely something to sit down and look at and think about when you are getting into one of these litigations. Here we go. Okay, so we talked about joint and several liability. So joint and several liability is not the kind of liability you want to have, because what it means is if you're one of the people who's responsible there, you're responsible for all of it, right? Everybody's responsible for all of it. And that's not good. You want to be just responsible for your own share and for what you did at the site. So yeah, maybe I put a whole bunch of metal into the water, but so did, you know, Abby, and so did Lucy, and so did Lily. They all put metal into the water too. Why should I be responsible for their metal and their contamination of the water? Generally under CERCLA, you just are, and you need to go in and you need to litigate how to divide up that responsibility. There's a case called BNSF, which Burlington Northern Santa Fe, I put sort of a citation in here so you could find it quickly. Very, you know, key case in this area of litigation that everybody should take a look at. And it does give you kind of an out from that joint and several liability. And that out is apportionment. So if you can look at the harm that was caused and say, well, this is capable of apportionment, we can divide this up. We can show what Lucy did and what Abby did and what Lily did and what Mom did, and we can just divide that up. And there's a reasonable basis for doing that, right? We can measure it. So we can measure what's in this section of the site where Lily operated. We can measure what's in that section of the site where Lucy operated. There's some reasonable basis for doing that. So let's not do joint and several liability here. Let's apportion the case. And when BNSF came out, there was kind of a big question in the community about, well, what is this going to do going forward? It was a case that kind of took a turn from that traditional concept of joint and several liability and seemed to indicate that it would be easier in litigation to start to apportion some of that liability. So there were lots of articles written about it. People started to put it into their litigation plans and think about, well, how can we argue that there's apportionment? The question that I think people are asking themselves now is, did we get kind of worked up over nothing? Because it seems like it didn't really matter. There was a lot written about this. There were a lot of concerns, but it seems like there aren't a lot of cases now where apportionment is actually happening. And in some cases, it's like apportionment is happening in the district court, and then the Seventh Circuit is saying no apportionment and sending it back down, and then it's going back up. Well, is there apportionment now? And it's coming back down, right? It's leading to kind of longer litigation about some of these issues, which maybe is good if at the end of the day you win, but you also need to think about whether or not you want to get involved in 15 years of appeals on whether or not you can apportion the harm under BNSF. So what I did is I cited the one case that I'm aware of where apportionment was deemed appropriate, and it's a nice example too, because it is the kind of case where you see how those two questions under BNSF can be answered. Is the harm capable of apportionment? Does a reasonable basis exist? So you have two PRPs in this Reifold case that is cited, where each of these PRPs had contributed enough contamination that you would need to put a cap at the site, right? So even if there was just one of them, you would need a cap. So the judge looked at that and said, look, it's if the contamination from either one of you would have led to the same remedy, then we can say that each of you is responsible, right, for that remedy. Each of you would have on your own required there to be a cap. And so we can just kind of cut that in half, because also there are just two of you. So if either one of you took actions that would have required a cap, then all right, we're going to split the cost of the cap. We're going to apportion the harm. And the court didn't bother going and looking at how much contamination each of the PRPs was responsible for. It was enough for that court to say, each of you contaminated the site enough that it needed a cap, right? So it doesn't matter if you contaminated it 10 and the other one contaminated it 100, doesn't matter. Either way, you need a cap. So why go ahead and even try to quantify that? There we go. Okay, so that's something to look at is apportionment and whether or not you can get out of that joint and several liability. Another thing to think about, and the one that I'm focusing on with respect to liable parties, is arranger liability. So you own a site, you operate a site. You're kind of in it, right? You can assert one of these defenses. Maybe you can find an act of God that gets you out of it. Good luck to you on that front. But proving sort of generator and arranger liability has gotten a little bit more complicated in a lot of the case law. So with arranger liability specifically, the idea here was that the statute was intended to prevent parties from kind of contracting away their responsibility for site contamination. So, well, I didn't operate on the site. I didn't generate waste on the site. I didn't own the site. Sure, I, gave John all of the empty paint cans that had a little bit of super toxic paint in them, and he said that he was going to bring them to the site, but that wasn't me, that was John. So John's really the one who's responsible. So arranger liability is something that has kind of evolved over the years. And when Charlotte was talking earlier about RCRA and the useful product defense, there are a lot of parallels in the analysis between being an arranger and that useful and being a useful product under RCRA. Because you're not an arranger if what you're getting rid of is a useful product, right? So you're not arranging for the disposal of waste at a site. if you are providing somebody with a useful product that then happens to contaminate a site. You actually have to intend to be disposing of that hazardous waste. And so intent has become an element of establishing arranger liability. And that has led to a lot of work in litigation of developing a record that can demonstrate intent. So to prove intent, you need to have the testimony of people who were involved in getting rid of the hazardous materials. You need to understand what kind of agreements or understandings a company had with the other person they were providing this material to, right? There's a lot of factual questions that are at issue when you're trying to figure out intent. And so when you're litigating arranger liability and trying to prove that a party was an arranger for the disposal of hazardous waste, it can be very fact intensive, and you should get ready to be doing a whole lot of discovery, a whole lot of document review, and a whole lot of depositions. I pushed the, yeah, it's still, I'm a little bit slow. I'm a little delayed on this end. And so one sort of basic thing to think about is that if you are basically getting rid of scrap or getting rid of refuse, you're more likely to be considered an arranger than if you are getting rid of a material that has an ongoing commercial use. So something that can be used in someone's business as like an element in what they're producing or as an ingredient in what they are making. And I have two cases here that provide kind of two different ends of the spectrum. So one is a case that is near and dear to my heart, which is the NCR, the first case, the NCR case, which was related to scrap PCB coated carbonless paper. So there was all this scrap paper that was coated in PCBs because the PCBs could encapsulate ink. And when you wrote on the paper, the PCB bubble would burst and the ink would go to the paper underneath it. So you would have carbonless copy paper. And, you know, for someone working on a case like this now, you probably don't even know. Probably most associates at law firms or young folks entering government agencies out of law school now don't even know what carbonless copy paper was, because this was back in the 50s, and they don't understand that it was this huge thing that totally transformed the way offices worked. People used tons of it. It was the thing. And so this is another kind of time I'll take to do a little aside on these cases. A lot of contaminated sites have really long histories. So you're not just talking about like what happened 4 years ago and, you know, trying to find the electronic documents and maybe the emails and all that kind of stuff. That's probably gonna be important, but you're also gonna be trying to find stuff from like the early 1900s potentially, or the 1950s. You're gonna be going through these sources of documents that are super old, and a lot of the people whose names are on those documents are dead. And so you can't find them and ask them what they meant when they told John they were worried that with these PCBs, the other shoe could drop at any time. Well, what did you mean by that, John? We'll never know because we either can't find John or John's dead. And then when you can find folks, a lot of times they're very old. And it is a burden and a difficulty to get them to participate in these cases. It's hard to find experts sometimes who understand the way wastewater treatment worked back in the 1950s, or who understand what were common practices for disposal in the 1920s. So the historical nature of a lot of these cases is honestly what makes them fascinating, because you get to go back and learn about all of these things, but it also makes them really hard to develop a record for a court, right? You need to have evidence that's admissible. And so when you're just kind of pulling random pieces of paper that came out of somebody's files and nobody can, you know, identify who was on them or who they went to, you can end up with some really kind of strange evidentiary challenges. So just to be aware of that, this isn't the place to go into all of those, but it's something that you need to be aware of, and you need to have a good team of folks who like to think about the rules of evidence and come up with creative ways to make sure stuff gets into the record. So coming back from my aside and talking about arranger liability, so this carbonless copy paper you had these PCBs on the carbonless copy paper, and then that paper was sent to recycling mills in the lower Fox River, right? Great, recycling, awesome. Except you're recycling paper with PCBs on it, and recycling paper takes a ton of water. You basically put it into a giant blender with a lot of water, you mix up the paper, and you pull out the fibers, and everything else goes through wastewater treatment plants. But, you know, back in the day, these wastewater treatment plants weren't pulling out everything. They didn't really even know how to pull out everything, including PCBs. And at first, they didn't even know the PCBs were in there. So you have all these PCBs going into the Fox River and a huge contamination process from this recycling. But in that case, NCR, which was the company that manufactured the carbonless copy paper, was not considered to be an arranger because they were selling, right? They were selling their scraps. So they would make their carbonless copy paper and they would sell their scraps to these recycling mills. And they were putting it in this really competitive market for recycled paper. It was part of a business model and a business design. And NCR was trying to recover some of their costs of production by selling their scrap as a commercially valuable product. And so they weren't considered to be an arranger in that context. However, when you look at the second case, this General Electric case, you have the defendant there who is selling scrap pyranol to a paint manufacturer at bargain prices. Just rule of thumb, never buy scrap pyranol at bargain prices. And so it's supposed to be used as a paint additive. And they're saying, well, you know, yeah, we're selling this valuable product that can be used as a paint additive. But when you go through the documents and the record and the evidence in that case, it's clear that the pyranol was not being marketed as a usable product. It wasn't going into a competitive market. And in fact, the folks who were buying it were kind of complaining that it wasn't really useful or usable, and they weren't going to pay for it because it wasn't doing them any good. So that's there's a big factual distinction between what was happening in the NCR case and what was happening in this General Electric case. That distinction needs to be brought out through discovery in these cases and then presented to the court to prove arranger liability. So two things. Oh, and I think this was probably this is what happens when you do your slides too late at night. So cost recovery and contribution, these are two complementary and distinct remedies. And what should you probably do? You should probably plead them both, honestly, right? So when in doubt, plead all your causes of action and wait for somebody to move for summary judgment on one of them. Because it might be the case that you can get cost recovery, it might be the case that you can get contribution. And to give a better sense of what these two remedies are, so it's section 113 and section 107 of CERCLA. You can find lots of really good introductory kind of articles on the distinction between these two, but like the whole RCRA scheme that Charlotte talked about, it's going to be confusing because there's still a lot of confusion about when a party can bring a section 113 claim and when they can bring a section 107 claim. So section 113 contribution claim is something that a potentially responsible party that has been subject to either a civil action under 106, so the government comes in and is like, dudes, you got to clean this up, or a section 107 cost recovery claim where someone's coming and saying, look, we've been cleaning up this site voluntarily and we think you're liable for it, and so we're going to sue you so that you pay your fair share. If that happens to you or your client, you have a contribution claim. If you settled through the government through an approved settlement, administratively or judicially approved settlement, which are important words in this context, you also have a contribution claim. So these are the things, these are the triggers that allow you as a party to go out and seek contribution from other people that you think are responsible, right? And if somebody is seeking contribution from you under section 113, these are things that you're going to look at to argue that the party bringing that case doesn't meet the requirements of the statute. So it's important to take a look at whether or not there's been an administrative or judicially approved settlement, and whether or not the PRP actually is subject to a 106 civil action or a cost recovery claim. And once a contribution case gets going, right? So once you've brought in all the parties, you have all these potentially responsible parties who are saying, we need to figure out, we're all responsible, we got to figure out who's going to pay for how much. You enter into what's called equitable allocation. Again, sorry, child bouncing on bed. Super fact intensive. And the way that this is evaluated is through what are called the Gore factors and the Torres factors. So the Gore factors are, in fact, you need to stop.
I need breakfast.
So the Gore factors are, in fact, factors that were put together by Al Gore, inventor of the internet, who help divide liability among multiple PRPs. And these are all pretty common sense, right? Like, can you demonstrate how much you contributed to the discharge, release, or disposal? What was the amount of the hazardous substances involved? How toxic were they? Were you generating? Were you transporting? Were you treating? Were you storing? Were you disposing? Like, what was your role in all of this? How careful were you? What did you do to kind of make sure that these hazardous substances weren't released? How much did you cooperate with the government when the government came in and said, wait a second, we're a little bit concerned about what's going on here? Did you open the door and say, come on in, let's talk and try to figure this out? Or did you say, leave us alone? We're not doing anything wrong. There's nothing to see here. Through case law, there have been developed a number of other factors called the Torres factors, which also help with this equitable allocation. And those include the extent to which the cleanup costs can be attributed to waste that a party is responsible for. So you have to put into evidence there a way to attribute those wastes to a certain party. The party's degree of culpability. How much did you benefit from disposing that waste? Did it make you this super profitable multi-billion-dollar company, or was it just kind of saved you $5? That could make a difference. And the party's ability to pay their share of the cost. So a lot of times companies are bankrupt. So that's one thing that comes into play here in thinking about the Torres factors. Equitable allocation, very, very fact intensive. Very important, because if you're talking about a site cleanup, I mean, I'm sure Megan and Charlotte can talk to you about cleanup costs that go into, the hundreds of millions to the billions of dollars, right? A lot of these sites are really expensive to clean up. So a difference between being responsible for 25% of that cleanup cost and 27% of that cleanup cost is actually a pretty big difference. And so these are issues that are pretty heavily litigated. You should make sure that you look at them all and cover them all and try to incorporate them into your development of the case. All right, so that is contribution, right? That's section 113 contribution, where you're arguing about, how are we going to allocate this cost? Section 107 cost recovery is a little bit different, and it's available to the government. It's available to private parties, and recently it appears to have been made available to potentially responsible parties. So it used to be kind of looked at as something that I'm going to say like innocent parties could use as a way of recovering any cost of cleaning up a site. But it has become something that even parties who might have contributed to the contamination at a site can avail themselves of in court is cost recovery. So in order to get cost recovery, basically you just have to show that you incurred necessary costs of response, right? So there was some sort of release, and I jumped in and paid $100 million in order to clean it up, because it would have been really bad if I had not stepped in and done something. I incurred necessary costs of response, and they're consistent with the NCP. So I can go through all of this set of factors that demonstrates consistency with the National Contingency Plan, and I can show that all of the costs that I incurred fall under those factors. Again, super fact intensive and would be too detailed to get into here. But something that just has to be done. So is this always available to me? Yes. So if I undertook my voluntary cleanup, I went in, I'm riding my white horse, wearing my white suit and white cap, and I cleaned it up. Nobody had to sue me. Nobody had to settle with me. I just did it because I'm a good person. Yes, I can use this. Did I hang out until DOJ had to like sue me or slap me with a Section 106 lawsuit. No, I don't get this. I don't get to come in and do and have a cost recovery claim. Are those the only two states of the world that exist? No, we don't just have the really good guys who go in and do everything voluntarily and the really bad guys who are really reluctant to clean up anything and wait until they get sued. There are sites that are really complicated and have different units that might be kind of a mixture of both of those things. Maybe you clean some of it up voluntarily, but not all of it. Maybe you didn't have necessarily, there wasn't a 106 action, but maybe there was some sort of agreement that you had with the government that doesn't really clearly fall under the language of CERCLA. There's a lot of ambiguity and complication there as to whether or not you can bring a Section 106 suit. So why do you care? Why are you even figuring out if you're eligible for Section 107? Like, why don't you just go ahead and do contribution? Well, there are some benefits to being in the 107 world, if you will. If you're allowed to bring a 107 action, you can get basically joint and several liability against any other PRP, which means you walk in and you say, I cleaned up the site, I spent a lot of money on it, and these folks all, I can show that these folks are all owners, operators, you know, arrangers, and they meet those four sort of elements that we talked about earlier under CERCLA. So if I can show those four things, those folks are joint and severally liable, right? And nobody wants to be joint and severally liable. I want everybody else to be joint and severally liable if I'm the one coming in, right? That's great for me. I want to be in 107. If I bring a 113 claim, I don't get to just say, all these elements are met, they're joint and severally liable. I have to come in and say, here's how you allocate liability. John is responsible for 13% because he did X, Y, and Z. Fred is responsible for another 14% because he did X, Y, and Z. So you can imagine that the burden of putting on that case under 113 is a heck of a lot higher than being able to have a 107 case. So there are a lot of reasons why people want to be in the 107 world and have a cause of action under 107 as opposed to having to go the 113 route. There's also a difference in the statute of limitations. I may have frozen up there. So under 113, you only have a 3-year statute of limitations, and under 107, you have a 6-year statute of limitations. I'm going to stop for a second, Chandler, and get a thumbs up from you to make sure that I have not gone offline.
You just have about a minute left.
Okay. So the moral of the story, I think, is plead everything. Plead 107, plead 113, try to figure out how it all shakes out. Some of these practical considerations that I also wanted to throw out there for folks who have not been involved in environmental litigation in the past is, you're not going to have a jury trial, you're going to be in front of a judge. You might have a judge who's been involved in environmental litigation before, but you might not. You might have a judge who's comfortable with science, and you might not. You need to be able to explain all of this stuff to that judge. It's a super complicated regulatory regime, and you know what? It has a lot of acronyms. Everyone uses acronyms every 5 seconds. Can't use acronyms. You need to be able to go in and use the whole word, and you also need to be able to put it in context. As a litigator, that means you need to call your friends like Charlotte and Megan and say, help me understand how this works so I can explain it to the judge. And I'm going to stop talking now, Chandler, because I think I got so excited about all of it that I hit my limit.
Great. Well, thank you all so much for your excellent presentations. We will now move right into our Q&A. So just as a reminder to our participants, please send us your questions using GoTo's question box. And we do have a number of questions already. This first one is, what sort of disclosures, if any, are required for property buyers or renters on formerly contaminated sites that have been cleaned up? I think that's really for anybody who wants to answer it.
Yeah, so having worked in the real estate field for a long time, I've had some time to think about this. The first thing that you would think about is sort of, what are your common law obligations as a seller to disclose any latent defects in the property, which contamination might be a latent defect if you have knowledge about it, but you think that perhaps no one else would be able to discover that. Most states have requirements that you disclose latent defects in a transaction. You'd also have to look at your, let's say it's a commercial, between two commercial parties, some sophisticated parties, your contractual document would spell out what your obligations are, your representations and your warranties. If the site is contaminated and it's been cleaned up, generally there is an environmental covenant or some other sort of recorded document in the land records that specifies what sort of notice you need to give to a prospective purchaser and what sort of notice you might need to provide to the agency that was responsible for the cleanup. So that's sort of, there's two different answers kind of based on whether it's been cleaned up or not.
Great. So other question that we have here, do we have any kinds of laws or regulations that regulate the movement of hazardous wastes between the states?
I feel like maybe that's a Charlotte question.
I can start and then I'll ask you lawyers to finish. Well, under RCRA, no. I mean, a state can't stop you from shipping your waste into that state, and you lawyers can explain why. But in general, states can have more stringent requirements, and so some states, at least in the past, it's getting less and less, especially with the electronic manifest, did have some additional information that needed to be included on the manifest. And so you had to, there was sort of a complex, you have to look at the state that you're shipping into and then maybe states that you're shipping through. But in general, the DOT requirements and the RCRA requirements don't vary a lot, or the DOT at all, I think, and the EPA RCRA requirements don't vary much across states.
Did anyone else have anything to add there?
I can just think sort of anecdotally about, things like not just hazardous, but like nuclear products, things with radiological impacts, local jurisdictions and states trying to enact restrictions on, let's say, bringing a train load of nuclear material or even fracked liquid on a truck or a train. But generally those are preempted by federal statutes and regulations, so that it's difficult for states to do that because, if that weren't the case, if the federal government didn't have sort of a uniform policy, then of course nobody would want that traveling through their neighborhood.
And actually, Megan reminds me of another point that states can be more stringent under RCRA. So some states do regulate as hazardous materials that are not regulated under the federal program. Mm-hmm. So if you're shipping materials into a state, for example, where that material would be hazardous from a state where it's not hazardous, you end up having to look at the receiving state's requirements. PCBs are also really tricky. There are varied regulations between the states for PCBs. So shipping and manifests are also kind of tricky, particularly for PCBs.
Great. Another question we have here is, as we learn more over time about how effective remediation strategies are there many examples where remediated sites are relisted based on new information that a remediation strategy used in the past wasn't as effective over time or as understood when it was put in place?
Yeah, so I can think of one Superfund site, the only one that I actually know of in New Jersey that was actually relisted. It was listed on the NPL early on and cleaned up. And as the questioner mentioned, sort of remedial strategies and science has changed over that amount of time. They realized that citizen groups, the owner and the agency realized that it was much more contaminated than the original remedy had addressed, and that site was relisted. A sort of corollary to that is under the state programs, if you're gonna, go through a voluntary cleanup program, you're only protected for the information that you disclosed and that you've discovered at the time. And it is all based on the future use. So you could end up back in a program sort of relisted, so to speak, if your use changes or if you discover additional contamination. Almost all programs, whatever voluntary or what have you, if you discover additional contamination, it's going to need to be cleaned up. And one other thing that I think is important to note is vapor intrusion, which is a really important factor that when all of these programs were put into place, we, the scientific community, regulators, lawyers, did not understand how important, if you have contaminants in the soil or groundwater, that the vapor could actually move from the groundwater into the soil and into the building and cause indoor air quality issues, which are really, really significant. So a lot of early on cleanups didn't include something like a subslab depressurization system that would take care of that. And so, you know, there's been reopeners on residential properties, commercial properties to address vapor intrusion issues that were not handled because we just didn't really understand it at the time.
Yeah, Chandler, I would also just mention emerging contaminants as a huge issue, and it's going to get bigger and bigger and bigger. It may just take over the entire field. PFAS chemicals, per and polyfluoroalkyl substances, are a emerging contaminant of concern across the country everywhere, and it's an incredibly complex set of chemicals, extremely varied in terms of how much science is available to think about the toxicity and exposure potential. So that is going to be a huge issue over time as PFAS chemicals, they seem to be found wherever you look for them. So it's how we manage that as an environmental field is going to be a really tough one over time.
Yeah, some folks might take the opinion that we should stop looking for them because if you test for things, then you just find it. What's the point of that? But I'm actually in Michigan where we have a lot of those PFAS issues, and one thing I will say is that it creates a lot of complexity for people who are interested in brownfield redevelopment and on trying to reuse a lot of those properties, because it's hard to get people to invest in a property if they don't feel like they can get some level of comfort. And so a lot of times there is really, I think, a need to go beyond some of what you can get from the agency in terms of like no further action letters, and also have separate side and private agreements that will kind of allocate that risk amongst the parties who are involved.
This next question, it's written as a two-part, and I'm going to try to combine it into one. I think the gist of the question is, if someone is disposing a product and they properly disposed it at the time with the best science, so for example in the 1950s, could the current owner of the property still be liable under CERCLA if it's now determined to be an unsafe land or property?
Yeah. Yes, I mean, that's the CERCLA does not care about you. It does not. And so, yes, you're liable. Now, can you go in and talk about, can you take actions that will reduce that liability and reduce that exposure? Absolutely. If you end up in litigation, will you be able to make arguments that will reduce potentially to zero your ultimate responsibility for the cleanup at that site? Yes, but you are liable, and you are now in a position where you have to deal with that site cleanup.
Another question here is, a concerning trend that we're seeing is that domestic prisons and immigration detention centers are in high incidence of these facilities being built on contaminated land. Is there anything that we can do to combat this problem?
So I think I'm going to make the assumption that is, or I can answer it two ways. If it's contaminated land that's not cleaned up, then, you know, there's possible, you know, enforcement actions, there's possible citizen suit provisions before the prison is built. It also sort of makes me think about land use controls, that would be the type of decision that would be made by a local jurisdiction controlling development at that site. But if the site has been cleaned up and it's a brownfield site, then any of the new development needs to, you know, go through the risk assessment process and be proving that it would be safe for a prison. So I don't know if anybody has anything else to add to that.
I think the reality, as the cleanup programs, all of them have evolved. You know, in the beginning, I think people thought we could just clean them up and that would be the end of it. And over time, it's proved it's really hard and it's really expensive to clean up contamination. And so more and more, it's not possible to dig and haul, and you end up doing some kind of capped closure. And that usually involves institutional controls to ensure that that property gets, those controls get maintained over time as the property uses change over time. And that is a really hard thing to do. It's not human nature to be able to keep track of that kind of thing over long periods of time. And it's kind of boring. And so I think maintaining engineering controls and institutional controls over time is really, really tough. And so losing track of what issues there may be at any potential site up for development is something we've got to get better at.
Yeah, and I think you say it's the human nature piece. It is also, I think, surprising to people. If you're involved in a litigation on a Superfund site, visit it. You have to visit it. You have to actually go and physically be there and see it. And you need your experts to go and physically be there and see it. And you will be surprised that there are, you know, some areas like open pit mines you look at and you say, this is terrible and horrible. Of course, it's expensive to clean up. You can walk onto a beautiful green field and it looks perfectly, but that is a more expensive cleanup than reclaiming that entire open pit mine that everybody can look at. So it's really, it's just hard because some of the sites, it's not visible. You can't see it, but it's dangerous and it's expensive to clean up.
We have time for one, maybe two more questions. This question is, could you go into further detail about soil and how it falls into the RCRA regulatory structure? Is it considered a solid waste or a potentially hazardous waste if it's contaminated?
That's not fair to ask that question in public. That's a really, really tough one. And there are all kinds of specifics that will apply in any particular situation. But just to give you some hints, contaminated media, the media itself is not a waste, soil, groundwater, but there may be a waste in it. And depending on what that material is and potentially what state you're in and potentially who has been involved and knows what's going on, you may find different answers. That's an incredibly difficult question. But the basic point is to try to acknowledge that media itself is not a waste. Stuff in that media may be, and that stuff needs to get managed properly. So figuring out how to do that is one thing. Figuring out the complexities of the sort of regulatory structure is difficult. If you have questions on that one, send me an email sometime. There's lots of writing on it, and it's complex but figure outable.
I think this is a great final question that you can all answer is, what really is the role of insurance in this arena?
That's a huge one. Insurance, well, that depends on a lot. Like if you have a factory that's been operating and has continued to operate for 100 years, it's very likely that you have layers upon layers upon layers of insurance coverage. After a certain point, there was an absolute pollution exclusion in all insurance policies. So you have to work backwards from that date and do forensic investigations to see whether you can find the policy, what it covered, what your deductible, your self-insured retention is, and then layer it all together. And sometimes you have to get a settlement, but that can actually fund entire Superfund cleanups is the insurers. And some of them are bankrupt because of it.
So I'll add my piece on. I actually tried to include that on a slide that I didn't manage to get to. You might have a whole separate litigation about the insurance piece after you have the CERCLA litigation. And there are also there's a growing field of experts who work in this area. So it might be the case that really you're going to need to hire for litigation purposes somebody who can go and do that forensic analysis for you, and then we'll be able to testify as an expert at the trial about how that coverage is going to going to fall out.
And I guess in my world, what we've find is over time for us, the insurance or whatever financial instrument you're using to cover corrective action cleanup costs, projecting forward is the tough part. Trying to figure out how much is this cleanup going to cost over time is the really hard part. And so if you don't do that well and it's well underfunded, either insurance or whatever instrument, it doesn't go well. So the cost estimating piece of it is critically important.
Well, thank you so much to our participants for joining us today and for your thoughtful questions. We hope you all continue to think about the foundations of environmental law and especially hazardous waste and sites. We are so grateful for your participation in ELI's annual summer school series, and we hope you come back for the Law and Policy of Products Regulations next Tuesday. I also want to extend an enormous thank you to our fantastic panel, Charlotte, Megan, and Margrethe. You've all contributed so much, and thank you for lending your expertise to summer school. It was such a pleasure to be with you all today. Thank you so much. Take care and stay safe.
Thank you.
Thank you all.